Hello guys, this is Rishabh and you are watching Institute of Legal and Management Studies. ILMS Academy, India's premier legal and management education portal. Get certified to enhance employability. The legal status of live-in relationship in India is intact and valid, as has been recognized by the judiciary in its various judgments, but to some extent still lacks social acceptance and continues to be a taboo. Introduction. Law and society are the two faces of the same coin, one needs the other. With the changing society, law cannot afford to remain static. From time immemorial, the law has been playing a significant role in changing society through its rules and regulations. It is very clear from the history of the development of Hindu law that the laws was never static and has been changed from time to time with the changing social pattern of society. The Indian society has witnessed a drastic change in its social pattern in the last few years. With the fast changing world, the Indians are gradually opening the doors of Western culture towards the ideas of premarital sex and live-in relationships. In India, there is no specific legislation or rules for regulating the matter of live-in relationship. The Supreme Court, through its various judgments, issued certain guidelines for the purpose of dealing with such relationships in India. Meaning of live-in relationship. There is no legal definition of the term live-in relationship. A live-in relationship is an arrangement of living under which the couples which are unmarried live together to conduct a long-going relationship, similarly as in a marriage. Live-in relationship is purely an arrangement between parties. Once a party to a live-in relationship determines that he or she does not wish to live in such a relationship, that relationship comes to an end. Hence it is called a walk-in and walk-out relationship. Live-in relationship is neither crime nor a sin, though it is unacceptable to a certain extent in the Indian society. In a country like India, where marriages are considered as a social foundation to legalize the relationship between a man and a woman, the concept of live-in relationship has set up a new dimension in the arena of men and women relationship. The legal status of live-in relationships in India. The Supreme Court and various high courts have given numerous decisions on live-in relationship. The Supreme Court in Badri Prasad versus Director of Consolidation gave legal validity to a 50-year-old live-in relationship. The court observed if a man and a woman who lives as husband and wife in a society are compelled to prove after half a century of wedlock by eyewitness evidence that they were validly married 50 years earlier, few will succeed. A strong presumption arises in favor of wedlock where partners have lived together for a long spell as husband and wife. Although the presumption is rebutable, a heavy burden lies on him who seeks to deprive the relationship of its legal origin. Law leans in favor of legitimacy and triumphs upon bastardy. In Payal Sharma versus Superintendent Nari Niketan, the Allahabad High Court opined that a man and a woman, even without getting married, can live together if they wish. This may be regarded immoral by society, but it is not illegal. There is a difference between law and morality. Live-in relationship between consenting adult is not considered illegal under Indian law. In 2006, in the case of Lata Singh versus State of Uttar Pradesh, it was held that a live-in relationship between two consenting adults of the opposite sex, though perceived as immoral, does not amount to any offense under the law. In S. Khushbu versus Kannimal, the Supreme Court held that a live-in relationship comes within the ambit of the right to life under Article 21 of the Constitution of India. The court further held that live-in relationships are permissible and the act of two major living together cannot be considered illegal or unlawful. In Alok Kumar versus State and another, the Delhi High Court observed, live-in relationship is a walk-in and walk-out relationship. There are no strings attached to this relationship. Neither this relationship creates any legal bond between the parties. It is a contract of living together which is renewed every day by the parties and can be terminated by either of the parties without the consent of the other party, and one party can walk out at will at any time. Thus, people who choose to have a live-in relationship cannot complain of infidelity or immorality, as live-in relationships are also known to have been between a married man and unmarried woman, or between a married woman and an unmarried man. In D. Velusamy versus D. Pachayyamal, the Supreme Court opined that relationship in the nature of marriage is akin to a common law marriage. Common law marriage requires that although not being formally married, The couple must hold themselves out to the society as being akin to spouses. They must be of legal age to marry, or otherwise qualified to enter into a legal marriage, including being unmarried, or voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. Hence, the court concluded that a live-in relationship outside the scope of common law marriage will not amount to a relationship in nature of marriage. In Dhannulal versus Ganesh Ram, the Supreme Court has ruled that an unmarried couple living together under the same roof are now going to be presumed married, and the woman would be eligible to inherit any legal property after the death of a partner. The bench reportedly said it is well settled that the law presumes in favor of marriage and against concubinage when a man and a woman have cohabited continuously for a long time. However, the presumption can be rebutted by leading unimpeachable evidence. A heavy burden lies on a party who seeks to deprive the relationship of legal origin. The Supreme Court in Shakti Vahini versus Union of India and others held that assertion of choice is an insegregable facet of liberty and dignity. That is why the French philosopher and thinker Simon Weil has said, liberty, taking the word in its concrete sense, consists in the ability to choose. In Nanda Kumar and another versus the state of Kerala, Justice A.K. Sikri and Ashok Bhushan has emphasized that a live-in relationship is recognized by the legislature itself, which has found its place under the provisions of the Protection of Women from Domestic Violence Act 2005. Recently in Ujjwal and another versus state of Haryana and others, the Punjab and Haryana High Courts refused to grant protection to a live-in couple who allegedly faced threats from the girl's family since the elopement, while noting that if such protection as claimed is granted, the entire social fabric of the society would get disturbed. Further, the court opined if such protection as claimed is granted, the entire social fabric of the society would get disturbed. Hence, no ground to grant the protection is made out. And the days after this judgment, the Punjab and Haryana High Court in Sonia and another versus state of Haryana and others observed that the concept of live-in relationship may not be acceptable to all, but it cannot be said that such a relationship is an illegal one, or living together without the sanctity of marriage constitutes as an offense. The court further observed that it would be a travesty of justice in case of protection is denied to persons who have opted to reside together without the sanctity of marriage, and such persons have to face dire consequences at the hands of persons from whom protection is sought. In case such a course is adopted and protection denied, the courts would also be failing in their duty to provide its citizen a right to their life and liberty as enshrined under Article 21 of the Constitution of India and to uphold the rule of law. Conclusion. A live-in relationship, though recognized by the judiciary in its various judgments, but to some extent still lacks social acceptance and continues to be a taboo. It is a choice of a person that should be free from societal pressure. One may believe in the idea of holy matrimony, but at the same time, one should not be criticized for his or her decision to consider a live-in relationship. So in order to protect the rights and interests of the persons arising out of such a relationship, proper legislative enactments are necessary. It is relevant in this context to say that there is always some madness in love, but there is always some reason in madness. Friedrich Nietzsche. Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.